Enforcement Directorate. Action by the ED against various politicians of opposition parties using the Prevention of Money Laundering Act is being projected by the opposition as a misuse of central agencies by the government to quell voices of dissent. The central government on its part says these are independent agencies and the law will take its own course. But why the ED action stings in particular is because of the special provisions of the PMLA, that's the Prevention of Money Laundering Act, that allows it to arrest without an FIR or really giving any reasons for arrest. Ability to attach property of the accused, and the law also puts the onus of proof, that means to prove that they're innocent, on the accused. These extraordinary powers, including making bail tougher than usual, were upheld by the Supreme Court in a 27th July order. Now, less than a month later, the top court will review its own order in open court tomorrow. This plea has been filed by Congress MP Karti Chidambaram and a three-judge bench of Chief Justice of India, Justice N.V. Ramana, Justice Dinesh Maheshwari and Justice C.T. Ravi Kumar. They will be hearing this plea. Now, this is important because just under a month ago, the Apex Court said very clearly that constitutionality of the PMLA has been upheld. And there were very important remarks made by the Apex Court in a nearly 545-page order. Among other things, they upheld the Enforcement Directorate's power of search and seizure. They upheld the PMLA's unique and special legislation, and that's one of the things that is being challenged tomorrow, that it was passed as a money bill. They said that money laundering is a separate class of offence, and that's why you need these many powers to go ahead and probe this offence. They said it requires stringent measures. Now, the petition that will be heard tomorrow questions many of these special allowances or special powers that the PMLA has. Among them, that the Code of Criminal Procedures do not apply to the investigating officers of the Enforcement Directorate until after the person is arrested. Basically, in other cases, police officers have to explain to the people they're arresting why they are, charge sheets have to be filed, etc. That's all under the CRPC. That does not apply in the case of the PMLA and officers of the Enforcement Directorate. It also challenged the court's finding with respect to the validity of the twin bail conditions under Section 45 of the PMLA, saying that the judgment erred in not appreciating well-settled principle of law that bail is the rule and the refusal of bail is the exception. The most contentious part of the law, which have been criticized or have been questioned by opposition parties, is that the way property can be attached by the Enforcement Directorate. Under Section 8, confiscation of property has been allowed even until guilt is proven in a court of law. So even when the investigation is on, at any point, properties can be attached. Section 24 is another important one. Burden of proof. And that is the point where the Supreme Court had in July upheld reverse burden of proof. That means if you are accused, you have to prove you're innocent and not the other way around. Section 45 is another important one. Conditions of bail include twin conditions of bail. So what do you mean by twin conditions of bail? That means that the public prosecutor has the first right to oppose the application of bail by the accused, and the court also needs to be satisfied. So to get bail, the public prosecutor and the court both need to be satisfied. Section 50 is another important one. It includes summons, production of documents, etc. And it says that the Enforcement Directorate's ECIR, which is their version of an FIR, cannot be treated the same. The ECIR is an internal document. That means the basis on which those arrests are being made need not be shared with the person accused, and they don't have to be told what the reasons are. So all of this will come up in court tomorrow. The context of this is very important because no matter what party you look at in the opposition, from Aam Aadmi Party to Congress to RJD, across the board really, all of them say, the TMC, all of them say that they are being unnecessarily and wrongfully harassed by the Enforcement Directorate, and all of these special powers that I've mentioned are being misused. Now, what can we expect in court tomorrow, and why is this such a crucial hearing? To speak on this, I'm joined now by Sanjay Hegde, Senior Advocate of the Supreme Court, and Desh Ratan Nigam, lawyer, who's joining us on the show. Welcome to both of you, and thank you so much for speaking with us on Beyond the Headline. Mr. Hegde, the fact that the Supreme Court has admitted this plea just under a month after it upheld the PMLA, what is that telling us? That they are open to re-looking at some of those stringent measures?
Well, we'd be jumping the gun to tell you that they will definitely re-look at what has been upheld so far. See, the review window in the Supreme Court is much narrower than the ordinary window of petitions in the Supreme Court. A review is if there was some material which would have changed the decision. If that had not been brought to the notice of the Supreme Court, of this court, and it could not legitimately have been brought for legitimate reasons, supposing it was some evidence which was not available at that point of time, then you really look at the judgment itself. Most review petitions are dismissed in the chambers of the judges themselves. It's a rare review petition which the court says, look, I think there is a point, let's have an open court hearing. Now, I do not know tomorrow how much time they will have for the open court hearing, because at the end of the day, the Chief Justice is due to retire on Friday. He is part of the review bench. So, and the two judges who were earlier part of the bench which upheld the PMLA, along with Justice Khanwilkar, they are also there. So, how exactly the hearing will go tomorrow, it may have to be watched. It may well be that they will set the parameters of the questions that they think need a second look at. They may then set a timetable for arguments, and that will obviously be after the Chief Justice has debited office and somebody else may come on. But the very fact that they have decided to have a relook at this judgment in open court indicates to me that they are not, they have not closed their minds. And one more thing that I'd like to tell you is that there have been instances where the Supreme Court has decided to review, and those questions are still at large. For instance, in the Sabarimala case, where Justice Khanwilkar was part of the earlier judgment which allowed entry of women into the Sabarimala temple, and thereafter, in a review, he said, no, we'll have to relook at the judgment. He was part of the majority which said that we will await decisions in other cases and keep the review pending. The fact that a review is pending may have consequences. What is to happen to any investigations or prosecutions that are currently in progress? Will you say that those who are in prison may have the benefit of the ordinary law of bail? Because at the heart of this harsh law is the ability to shut somebody up under a PMLA case and then deny him bail. That is the real teeth that the Enforcement Directorate has.
Right.
So if that provision, for instance, alone were to be kept in abeyance, then there would be much to look forward to the final argument in the review petition.
All right. So
I, for one, do not think that there will be a full hearing of the review petition tomorrow.
Okay, so maybe it's the start of a process. I want to put this in perspective of what we can finally expect as an outcome. Desh Ratan Nigam, this has clearly become a bone of contention politically as well, with opposition parties saying that, look, this law is being misused. It was there always, but it's being misused like never before. Anyone who wants to speak up is, struck with this PMLA, and then they have been put behind bars, they don't get bail, etc., etc. So in that context, do you think this is a very, very important review petition that we're going to be looking at from tomorrow?
Tamanna, in fact, the CJI had, disclosed his mind in a public function with respect to attachment of properties, and he had certain concerns. And he did say that this particular aspect of the judgment needs further expounding, means further clarification and explanations. So I don't know whether they'll confine themselves to this particular aspect or to all other aspect is something we don't know. But the fact remains, and to a very large extent, I agree with Mr. Hegde about the procedural aspects, whether it will be heard or not heard tomorrow, which we know because he's got to attend a function in Delhi High Court as well. To felicitate him for, for his, since he's going to retire very soon. So I can agree to that extent that probably full hearing may not take place. Even if full hearing takes place, it is not going to be a matter of one sitting one day. So, and secondly, this is a special act which has been created on account of United Nations resolution to prevent money laundering and confiscate property. Although its scope extent has been increased a lot by our parliament. That our parliament is sovereign and independent, so it can do so.
Are you saying, Mr. Nigam, that it does not need to be reviewed? That it's fine the way it is?
No, I'm saying it is fine, absolutely fine. However, if they require certain clarification, certain, safeguards to the extent of, something, it's a special statute. It takes precedence over the general IPC. So that's a law well established. The fact remains, there are huge checks and balances in this act. Under the ordinary Indian Penal Code, a person can be arrested for mere suspicion. But here, in a sealed envelope, one has to show the material and the reasons for arrest, and the court has to satisfy for the arrest. That person arrested has been done so. Even subsequently, even if it is the property attachment is there, it is provisional and it has to be given in a sealed envelope, all the reasons, and it has to be confirmed by court. It is not that it will continue like that. So there are various checks and balances out there.
Sanjay Hegde, there are enough checks and balances in the system as it is, says Desh Ratan Nigam. That this hue and cry about, ED having these unfettered powers and possibly misusing them as the allegation stands is unfair.
I totally disagree. Listen, let's get to the phrase money laundering itself. Money laundering came out of the days of prohibition in the US, where the mafia led by Al Capone had to show how it earned its money. So they opened laundries where people normally paid cash. And that's how the phrase money laundering came up. Now, the UN conventions were in respect of terrorism and drug money. So if you had proceeds from that, your economic strength had to be taken away. Therefore, their properties could be attached, etc., etc., etc. That is the basis. Now, what has happened is that each and every crime, ordinary IPC crimes, supposing I was to hit Mr. Desh Ratan Nigam and he was to put in attempt to murder case against me, even that conceivably could come under the ED's purview, because that 307 is also a predicate offense. Everything and anything in the IPC
are there examples, Mr. Hegde, that it has been used like this? Because it seems like a stretch of imagination. No violence on the show, real or notional. But even so.
Please check the schedule. Please check the schedule. That is why now I was looking at your visuals. Some chawl redevelopment did not go well. There was a 420, which is cheating. There may be some documents which are wrong. All that also becomes a predicate offense. You file a PMLA case. The ECIR need not be given. You put the man in prison and then deny him bail. Because what are the conditions of bail? That A, the prosecutor must be given notice. Then that the judge must be satisfied that there is no case. And that if you are given bail, that you are unlikely to repeat your offense. There are judgments of the Supreme Court, the same Justice Kanvilkar, who said that no, you can't do this on a prima facie basis. You almost have to have a complete trial. And at the end of it, you decide that the man is innocent, you give him bail. So therefore,
okay, Desh Ratan Nigam, your response. You're not agreeing with what Sanjay Hegde is saying.
Just 1 minute.
Okay.
Let me complete.
All right.
This has empowered a division of the finance ministry to become much more powerful than the policeman under the home ministry. And that's why it gets used like that.
Okay, anything goes under the PMLA, and that's the problem, Desh Ratan Nigam. The claim is
Yes.
that this is for financial misappropriation. These are supposed to be financial crimes. And as the government has been arguing, it also is being used by terror organizations. Now, every political party of every hue that is in the opposition finds itself, one leader or the other, at the receiving end of it.
See, I am not going to comment on the politics of it because it is, at the end of the day, courts will decide whether a person is guilty or not.
No,
However,
but
let
sir,
me-
it is very related. I'm sorry, I will allow you to complete your answer, but I must say that it's very intricately linked.
No, it is not. That is the presumption that everybody is making, that it is being misused. It is finally the court will decide that whether it has been misused or not. It is up to the courts to say. At this stage, we cannot say a person is not guilty. The fact is, it is a presumption under the fact that under the law that he is guilty till proven innocent. It's a jurisprudence that we have taken from.
Isn't he supposed to be innocent till proven
That has been
guilty?
reversed here.
No, it has been reversed under Section 24.
Exactly.
The burden of
Yes.
proof has been
Exactly.
reversed, and this is because of the special nature of this particular act and the crimes being committed. Let me bring out the final point between IPC and the Money Laundering Act. There may be, IPC being committed, the crimes being committed, and money laundering also being applied. The proceeds, which are the crime money, which has been earned by committing a crime under various crimes mentioned under the schedule, which is being, made into a legal money, a process of crime money being converted into a white money, legal money, and the proceeds of the property being purchased from there. It is for that, to punish that crime. Otherwise, the initial crime that you have done will be punished under IPC. Therefore, this is a very special act. That distinction has to be maintained, and that Parliament has maintained that distinction. Whether you get acquitted or not in that particular crime or not, because the burden out there is very strict in the IPC. But here, if you have earned the crime money and converted it into the white money and bought property and you have projected it as that, then that is a crime under the money laundering. That is what money laundering is all about. So that distinction has to be maintained. The two cannot be compared. So it's a special act and has to be dealt with accordingly. Otherwise, provisions like attachment, if it is not there, the third party rights can be created, the property can be sold, nothing can be done afterwards. So all this is a check and balance. It is done under the supervision of a court, not on the whims and fancies of a investigative
Why
agency.
is the jurisdiction of the court and the oversight of the court not enough of a check and balance in your view, Mr. Hegde?
Where does the court come in? It is not as if the court approves the ECIR before it is filed. And who determines that a crime has been committed? It's not as if after a conviction that you come in under the PMLA. What you say is that this man has money, this man has this asset, he is accused of this crime. So in the meanwhile, I will have a PMLA, I will arrest, even if he is not arrested in the basic offense, I will arrest him. And it will go on and on. Today, a Bombay special court said this court strongly feels that it cannot join hands with vengeful complainant like ED to humiliate accused persons by continuing their judicial custody, that too in utter disregard to the recent law of the land. What the ED has been doing has received many compliments, not only from politicians, but now the courts are also getting in. And, you spoke about inextricable politics in it.
Yes.
And Mr. Nigam denied it. Mr. Nigam will, of course, deny it. It is not inextricably linked to the BJP. The BJP doesn't suffer under it. Every other political party is inextricably linked to the ED.
No, I was talking about politics overall. I'm talking about politics, and the ED and the PMLA is inextricably linked. There is no denying that. Desh Ratan Nigam doesn't want to talk about the politics of it. But the fact is that at the receiving end of it, prominently, and I'm sure there are others also who are being probed under PMLA and by the ED, but the politics of it has hogged the headlines and has become, at the forefront of the story, Mr. Nigam. Because the idea is that if you can quell political dissent with the use of a law, then where does that leave us?
the fact is we both are lawyers and our expertise is in the field of law. Politics, we need to be very sure with evidence before accusing anybody. So at least I am being very careful before I accuse somebody that it has been done purely out of politics. If I have
There's no way of knowing, right? You're right when you say there's no way of knowing till these cases are handled. But my question to you, Mr. Nigam, let me rephrase the question and put it clearly, because obviously I'm speaking with astute lawyers. So let me be very specific with what I'm asking. Do you, in your personal view, believe that none of the cases that the ED is pursuing right now have any political motivations behind them, and that it's a coincidence that a large number of only opposition leaders are at the receiving end of investigations from the ED? Do you see it all as a coincidence?
Can I rephrase your question one minute more, Mr. Nigam? And can Mr. Nigam also tell us that if people join the BJP from the opposition, do those cases get pursued with the same vigor?
Let me answer that. The fact is, I don't have any material to come to the conclusion that Tamanna ji, you have just told me. Therefore, so far as misuse, I can speak about generally. Any law which has been made is subject to misuse, whether these are dowry laws or domestic violence we have seen. So possibility of misuse is always there. Use and misuse will always go in hand. Whether an individual case is a case of misuse or not, is finally the court will determine. Yes, there are people making presumption because of politics and political perception is being created. There is a separate political battle going on with respect to perception, which the political parties will indulge to depending on the individuals, depending on which side of the divide you are. And that will continue forever because we are in a competitive democracy where political parties compete with each other. So far as law is concerned, law is clear, black and white, and possibility of a misuse has to be quelled. Anybody who misuses has to be punished. And I'm very clear about that. Anybody who tries to, and so far as, people joining BJP, everything comes under the supervision of the court. Courts can only be the washing machine. Let me tell you, and I've time and again answered, once it's only the court that can wash your stains. Nobody else. They can, acquit you, then your stains are washed. But no political party can be a washing machine because once the case is registered, it is under the supervision of a court.
Your response to that, Mr. Hegde, your response to that at the end of the day, do all of these cases and charges actually hurt the political parties, or is the real threat that ordinary citizens will be at the end of a law which may not have the required checks and balances?
It hurts not only the political parties, but it hurts a lot of ordinary citizens. It also spreads an atmosphere of fear among the business community. You are never sure of any transaction. Even supposing you have bought a property from somebody, later that man comes in under the purview of the PMLA. There have been attachment orders where the property has been transacted twice, thrice over. All kinds of things have happened under this act. And the basic thing is that there is no supervision, there is no training, which an ordinary policeman also gets. And every bit of the law is trained in the interest of the prosecution and the normal law that is applicable to all citizens, that you are presumed innocent till proven guilty. That is not there. Your properties can be attached pending a trial. And most importantly, you can be put away in jail and said, okay, now let...
Mr. Hegde, serious question. I'm not talking about the use or misuse or alleged misuse of the law right now, because that is the allegation. And of course, all of this will probably be discussed in court. But to the moot point of how do you track and investigate financial crimes, which include misappropriation of funds and using proceeds of crime. That is the basic reason, if we go back to the core of it, why the PMLA was given such unique powers. Can you really do your job as an investigating agency if you don't have all of these tools?
Absolutely. Of course you can do it. What is your conviction rate after that? Very little. What is it that you can achieve currently? you have the ability to keep people in prison, and then thereafter you are not even concerned with actually proving your case and proving them guilty in court. So actually, the more harsh a law that you make in favor of the government, the more lazy you make the government officers. The absolute power to make a citizen's life miserable is enough in itself to then say that, okay, we have taken our revenge. Now if he gets out after 6 years, 7 years, whatever, that's fine by us. Let him run the gauntlet through
Mr.
courts.
Nigam, your closing comments. Punishment, the process becoming the punishment, that's one concern and contention. And the other is that does this law in its entirety, because you want to look at it just from the legal framework, does this law require review?
See, let me tell you, there may be certain clarifications or expounding as the Supreme Court CJI in a private function hinted, although I am not in favor of CJIs, disclosing their mind in private functions of the cases that they are hearing. And that actually makes them unfit to hear that particular case. But then that's a larger question. I leave it for another debate. But so far as conviction rate this is concerned, 25 cases have been decided in which 23 convictions have taken place. Number of cases decided and number of people convicted, it's above 90%.
3,000 plus cases filed.
Filed, yes. But how many adjudicated finally and convicted is one you have to see. These cases take a lot of time. So above 90% conviction rate, which is there, so far as the cases which have been decided. So let us go by that. That is how you calculate the conviction rate. And let me also tell you, yes, it's fine. The judges are within their, rights to actually review it. But I think, and I can, say with some degree of responsibility that it's not going to be set aside, but certain expounding or clarification, as already hinted, may take place.
Comes off this? Yes,
I have a quick...
yes, Mr. Hegde. Quickly, please.
The people also ought to know that this act did not go through the entirety of Parliament.
Yes, it was passed as a money bill.
Rajya Sabha. It didn't go through the Rajya Sabha. And that question is still at large. That has to be decided by a 5-judge bench. And if the 5-judge bench says that you can't pass these laws by going through the Rajya Sabha route, this entire thing will fall down.
That appends a lot. Then that is a whole different story and a whole different discussion about passing crucial laws like this as money bills. That's part of the petition that will be heard tomorrow as well. But it's an important hearing tomorrow. It's a crucial matter because it's not just a matter of law. It is a matter of how this law is being used and the impact it is having on politics today. That's why I want to thank both of you for joining us and helping our viewers understand and explaining what the implications are.